Good morning and welcome to the second of our weekly Meet the Expert question and answer sessions with Sintons Employment Team. My name is David Pritchard and I'm the Head of Marketing here at Sintons. Once again, can I say how delighted we are that so many people have signed up to view the session today, and also the amount of questions we've received again this week has been absolutely phenomenal, so thank you very much for that. Very quickly from me, and just for the benefit of those people who are joining us for the first time, these sessions have come about due to the employment team here at Sintons having been inundated with COVID-19 and furlough related questions following the introduction of the coronavirus job retention scheme and the ever-changing government guidance. The team have also been given some thought as to what work may look like following the relaxation of the current restrictions. So in order to give you an opportunity to share in some of that wisdom, the team have opened themselves up to these Q&A sessions, which are going to last every Friday until the end of May. Obviously appreciate that we're recording today, Thursday, and that's with it being a bank holiday tomorrow. So during these sessions, members of the employment team will answer 3 questions, and they can be either COVID-19 related or not, that you haven't quite got to the bottom of, or that your employees are persistently asking you. So I'm just going to move the screen on. Our speakers this morning: Keith Land, Head of Employment here at Sintons, and Associate Angela Carver, and obviously me just introducing. So without any further ado, I'm going to pass you straight over to Angela for question 1 of 3. Angela, good morning and over to you.
Good morning, David, and good morning, everybody, and thank you for logging in. The first topic which I'm going to look at this morning is what happens at the end of furlough. We've had a number of questions come in about the semantics and how an employer deals with the return. Now, the job retention scheme will be in place until the end of June 2020, pending any further amendments by the UK government. Just as part of background, and I'm probably teaching you all how to suck eggs, a furloughed employee has been instructed by the employer to cease all work in relation to their employment. The period for which the employee has ceased or will cease, as there are still employees who have not yet been furloughed, will be for a period of 21 calendar days or more. The instruction to cease work is given by reason of circumstance arising as a result of coronavirus or coronavirus disease, and the instruction to cease work must be agreed in writing. This can be by electronic means. Now, whilst an employee must cease all work in relation to their employment, this does not permit an employee from working elsewhere, or for an employee with 2 jobs to be furloughed from one role and not another. On that point, and to cover off another question, so in theory we are doing 4 today, if an employee on furlough has taken up employment with another employer and now wishes to remain with that employer, the employee will need to provide the notice to their former employer, formerly employer, with the required notice under their contract to terminate in the normal way. And Keith will be looking at the issue of notice after I've dealt with this topic. Now, as the job retention schemes draws to a close, it would be sensible to give reasonable notice in writing that an employee is to be de-furloughed and expected to return to work on the 1st of July 2020 or sooner if needs be. As an employer, you also need to consider the semantics of the return. Are all employees now coming into the workplace? And if so, how will you manage this? Is home working viable for staff and how will you utilise it? Do you have a home working policy? Will you have various shift patterns in place to enable social distancing? How will you enforce social distancing? Do you need to consider any adjustments for disabled employees? What about childcare arrangements? What about employees who do not want to come into the workplace for health reasons? And key, is there an intention to reduce hours or the working week for your employees returning? Do you need to make amendments to contractual terms? Do you need to undertake risk assessments? And how will you deal with organisational change? It's quite a number there. I anticipate a number of workplaces will be looking at how to save cost at the end of the job retention scheme, and the likelihood of employees working a reduced week or taking a reduction in salary will likely be high on many employers' agendas. It's important to note that if a change to the employer's contract is needed related to matters such as salary, in the absence of an express contractual provision permitting a variation, consultation about the amended terms will need to take place with your employees. If you cannot agree to a change, there are a number of options available to you, namely make the change anyway, but this could result in a breach of contract and a claim for constructive unfair dismissal, or termination and re-engagement of the employees on new terms. The employee could, however, refuse re-engagement and claim unfair dismissal. Just as a side note, if you're intending to dismiss and re-engage more than 20 members of staff, this could result in a mass termination and would fall within the terms of collective consultation. Personally, I think a claim brought on the basis that a company needs to amend contractual terms in these unprecedented circumstances will be defendable, and provided the change is reasonable, has been applied fairly, and a fair process followed, I think an employer will be okay. I will talk about what happens when furlough ends, how to amend terms and conditions, practical advice and considerations at our seminar that we have on the 21st of May. But in the meantime, Keith, is there anything else you'd like to add?
I don't think there's much I'd like to add, other than to say I think in the current climate we've gone through a national crisis, the like of which that people haven't seen in a lifetime, haven't seen since the war, really, or the end of the Second World War. And so in terms of changing terms and conditions and doing things with consent or making unilateral changes, the pressures on business at the moment, or when we get out of furlough and we move on and we try and get the light switch back on and the economy running, the pressure on businesses is going to be huge, because cash is king, obviously. And therefore, when looking at those discretions that you might have under contracts, I think you've probably got more power to be a bit more bullish than ever. Now, that doesn't mean you can be gung-ho and just trample over employee rights, but in short, the tribunals will be more accepting of an argument around the seriousness of the financial consequences and the fact that employers need to move fast to do things to preserve the business as a whole. So I think you will have greater latitude to present arguments to the employment tribunals. As we say in the office, I'm fairly bullish, and then I run along the corridor and speak to Angela, and if she says, yeah, we're good to go, that's generally the case, really, because slightly less aggressive than me, so we try and find the right balance. Okay, I think as I'm talking, I'll jump on to the next question, really. Before I do so, we also had a team call last night where we had drinks and a quiz. And we got into the Urban Dictionary, and somebody was talking about the elephant in the Zoom, which is a new phrase for somebody on a conference call who's sprouted unnecessary facial hair. Well, I thought I'd move with the times and I'd go with it. What I actually thought was, frankly, if I grew some facial hair out my head, it would stop it growing on the top of my head, and so I wouldn't have to go and get a haircut like David's. But never mind. Moving on. Yeah, we had lots of Q&As, and the Q&A was around notice provisions during furlough. The actual question we got was, if someone on furlough is given notice of termination following redundancy, for example, do they stay on 80% pay, or does an employer have to top up to full pay? Right, well, like any employment question, you've got to start at the start. And with any employment question, there are a number of different matters that feed into the discussion, and you've got to sort of put them in their own silos. And they are generally the rights under the contract, rights under policies and procedures, rights under statute, and in this case, the rules on furlough. And you've got to look at all of those different silos and then decide what the overall answer is. Now, looking at the contract of employment, you've already agreed to reduce somebody's pay by 80%. So you have consent to pay them 80%, and that continues during furlough. So a big tick in the box there. If the employee can't do their job because of the coronavirus, then it seems to me that they can continue with the furlough arrangements. That's not in breach of the furlough scheme. So again, a big tick. Looking at your policies, is there anything in there that's likely to impact on notice? Probably not. So I think in this instance, you can probably disregard them. You then get on to statute, and this is where the issue is. Okay, the applicable sections are sections 86 to 89 of the Employment Rights Act. If you try reading them, you won't understand them. because it's gobbledygook even to me after 20 years of practicing. So the short answer is that you've got to look at the notice from the employer to the employee in the contract. And that, if that is statutory minimum notice, then you can then the employer is obliged to top up to full pay during notice. If, on the other hand, the contractual notice from employer to employee is 1 week or more in excess of statutory minimum, the person can remain on 80% pay for the period of furlough. Now, why the distinction? Well, who knows? I think it was probably that the government preferred to give blue-collar workers a leg up in terms of the financial position, because they're the people who are more likely to be on lower pay grades than white-collar workers. One point to note, that you might have somebody in the contract who has a month's pay, for example. They would look like, in that instance, that they're above the statutory minimum notice. However, once they get to 4 years employment and beyond, so for example, if you had somebody that had 1 month's notice in the contract, but they had 8 years service, you would default to statutory minimum notice, and that person would be entitled to be paid in full during the furlough period, because actually they are on statutory minimum notice. I hope that makes sense. Right, now let's look at the furlough scheme. What does that say about notice? Absolutely diddly squat. So consequently, it doesn't give any help whatsoever. However, the government said that recently, this time last week, that somebody acting as a union rep for collective consultation will not break furlough. So it stands to reason that the government is anticipating consultations to take place and potentially for dismissals to take place. And if somebody still cannot do the job, then I see no reason why they can't continue on furlough and be paid 80%, assuming that they're above the statutory minimum notice. However, this seems to go against the fundamental issue of the job retention scheme, which is to retain jobs, if you ask me, but I don't know the answer to that question. What I would say is there's a horrible little regulation in the job retention scheme. This is the actual instruction that came from HMRC to Her Majesty's Treasury, and it's Rule 2.5, which said no claim may be made in respect of an employee if it is abusive or otherwise contrary to the exceptional purpose of the scheme. So I suppose there may be an argument that HMRC may present after the lights have come back on and they may audit some clients and people that say, actually, the reality is that the job retention scheme was meant to save jobs. And if you were dismissing people on it and claiming their notice payment under furlough, then you should repay that. I think that's probably contrary to the intention of the scheme, because if the people are not able to do their job because of coronavirus, then they should remain on furlough. But there is that degree of question mark over it. However, look, what are you going to do? If you have to dismiss people, I'd get on and dismiss them, keep them on furlough, keep paying them the 80%. The worst that happens is the government makes a reclaim if you're audited in 12 to 18 months' time. And if you're still in business and operating, then you can probably come to some arrangement with HMRC to repay that at that point in time. I don't know how it will go. We will have to see. That's my skinny on it. Angela, I don't know if you have any thoughts.
Sorry, just unmuting myself there. I think the redundancy point is important. It is silent in the regulations. There has been new guidance provided in relation to disciplinary and grievances. But I absolutely agree. I think it's against the spirit of the scheme. However, in this climate, it is highly likely that employers will need to look at organisational change. And it's just whether or not we start the consultation now or after the furlough scheme. But I think the very reason the furlough scheme was extended when it was to avoid the collective redundancy pitch that would have been coming. So I think the government are alive to the fact that consultation can take place, but again, it's silent, and everything comes down to fairness and reasonableness. I might as well move on to the final question in this topic, and it's quite a big one. It's about childcare issues and attendance at work during this pandemic. We've had quite a lot of questions in relation to employees' rights. How do you get them back into work? How do we manage it? So I've tried to pull everything together. It is quite a big topic. I'm having to skirt over the issues. So it's not in the detail that we would usually give when we're giving advice. So just bear that in mind, please. So in relation to the rights that an employee has, just to set the background really, the Employment Rights Act determines that any employee, no matter how long their service, with dependents in the sphere of this question, that being children, living in their household, is entitled to reasonable time to care for these dependents. Now, this type of leave is usually used in emergencies such as sickness or disruption to termination in childcare provisions. It's important to note that in this emergency leave that the employer is under no obligation to pay the employee, and what's determined as reasonable time off is not set in stone and is subjective. In addition to that type of leave, we've also got a parental responsibility leave. So you've got up to 18 weeks per child, that's per child, not per child per employer, over the course of 18 years. So if you've got two parents with parental responsibility, they can actually take 36 weeks off to unpaid to look after that child. The difference with this type of leave is 21 days notice is required. The employees also have other avenues, such as making things like flexible working requests. And of course, the government has confirmed that those with childcare responsibilities who are unable to attend work for childcare reasons could be furloughed. Finally, what I would point out as well is that a woman with childcare responsibilities will have protection from discrimination on the grounds of sex, given that statistically, most childcare tends to lay with women. Now, if we imagine a working arrangement which indirectly places a woman with a childcare arrangement at a disadvantage, this could result in a claim for indirect discrimination. And unless you can justify the reason for the treatment, unfortunately, you will be subject to an award being made against you. There's a couple of final points which you should be alive to, which will not be relevant in every case. And that's the risk of associative discrimination if you have a disabled child, or the potential claim for whistleblowing if there's a health and safety implication in asking your staff to come back, which could endanger themselves or their family. Now, that's all good and well for your employees, but what if as an employer you need your staff to come in? First thing I'd say is we are in unprecedented times. Schools and nurseries are only open for children of key workers. Grandparents and other key givers are not on hand as they once were, and not all jobs can be undertaken from home. It may therefore be necessary to look at an amendment to working patterns, hours, shift rotas, or the place of work to keep your employee in work. Just as by way of an example of one of the questions that's come in, if you've got a member of staff who's contracted to work mornings, but due to lack of childcare, they can't do that, it may be that you need to look at varying their hours of work if they have capacity, for example, to work on an afternoon. As with the issues on amending contracts on the return from furlough, unless there's an express provision in the contract allowing a variation to terms or flexibility to change the working pattern, consultation will be required. Now, consultation is important because it allows you as an employer to understand your employee's position, their capacity, and the options, for example, to split childcare with a partner, and it could be that they could work part-time. Now, I've found that employees who are open and honest with their employees and discuss matters have achieved the most agreeable working arrangements. Now, even after consultation and being open and honest with your staff, they still don't have to accept a contractual change. Now, forcing a change without consent could again result in a claim for breach of contract and constructive unfair dismissal, and termination and re-engagement on new terms comes with a risk of unfair dismissal. And both courses of action could result in a claim for discrimination on the grounds of sex. Now, like Keith said, in this climate, there's most likely to be a legitimate business need for any change. Given the employer a potentially fair reason for dismissal, which we call SORSA, it's called some other substantial reason. And therefore, if your employee doesn't agree to a change, you would potentially have a fair reason to dismiss, provided you've acted reasonably, you followed a fair procedure, and that you can justify the reason for choosing a particular employee, bearing in mind issues with discrimination. So the reasonableness of any reason for a proposed contractual change and the reason for the rejection will determine the level of risk involved in your decision-making process. One final course of action available to you is subjecting your employee to disciplinary proceedings. And this is usually going to take place where they refuse to attend work, they abuse their time off for childcare, or they go AWOL. Now, I would again say that this is not without risk. So I've talk quite quickly to get through that. So your options: consult and discuss any change with an employee, explain the business reason and the need for everybody to be flexible at the moment. If they won't agree to the change, sit back and continue as you were. Have a look at things, for example, like temporary cover, force the terms on the employee, dismiss and re-engage, or dismiss for failing to attend work. As a business, everybody has to make their own commercial decision based on the needs of your business. And sometimes a risky decision may be needed to ensure the viability of your business going forward. Keith, any comments on on my little rant there?
Yeah, not generally, because it was a really good summary. So thanks for that. I think the one point that you did bring out, and I would echo, is if you are talking to somebody that has childcare arrangements and the risk of indirect discrimination, the cases are really clear that employers that engage, even if they don't accept what the employee wants and they put forward an alternative arrangement that tries to meet their requirements and the employees, tend to fare far better in if the matter ends up in the employment tribunal than an employer that is just a bit intransigent and does not engage in that process, if you see what I mean. There's one of the cases which deals with a chap who, not necessarily childcare, but you'll get the picture, who was a Muslim and wanted to go to the mosque, but his employer, he's a security guard, so he couldn't leave sight, and his employer said, well, actually, we'll give you a prayer room where you can go off and pray at certain times. The employer engaged. It tried to meet his requirements and tried to meet its own, and it succeeded when the guy brought a claim of indirect race discrimination. Not hopefully you get the point, but employers that engage fare much better. That's the only point I would add. David, I'll pass back to you to wrap up. Many thanks for listening, everyone.
Thanks both. Just so you're aware, the firm is working hard to produce and deliver useful and relevant content at this time in the form of articles, blogs, podcasts, and videos, question and answer sessions like this one, all of which can be found on our website at www.sintons.co.uk should you wish to take a look. And if you navigate to our homepage, we have actually got a Q&A portal around COVID-19. So if you want to have a look at that, there's about 50-60 articles on there. It also includes episode 1 of this Q&A series, which we recorded last Friday, and yeah, all up there for you to have a look at and disseminate at your leisure. You can also follow the employment team on Twitter at Sintons HR. If you'd like to raise, just move the slide. If you'd like to raise, discuss anything the team have raised today further, or if you have any other employment inquiry or any other legal inquiry for that matter, please don't hesitate to get in touch. And as I said, details of the speakers are on the screen. As I mentioned, we're going to be bringing these sessions every Friday until the end of May, and I will send a link round after the weekend for next Friday. So all that is left for me to say is from Keith, Angela, myself, my haircut and Keith's beard, thank you very much for listening, and we look forward to speaking to you next Friday. Stay safe, everyone. Thanks for listening.